There is an urgent revision petition. Can I move it tomorrow, madam? I'm told that this Congress Cooper is not sitting, so I have to make a mention.
Okay. Tomorrow. What is the urgency?
Urgency matter one injunction matter, ex parte injunction has been taken. After that, we have argued our part. At least 4 or 5 dates have gone. Final order is not being passed. So I want a direction that it should be disposed of.
Tomorrow.
For withdrawal tomorrow. Regular constable for withdrawal tomorrow.
Huh?
For withdrawal, man.
Tomorrow.
Oblige.
Should mention for listing of matter, FAO, Lordship rejection of injunction by the learned trial court. Should there's an urgency in the matter for tomorrow?
Tomorrow.
I beg to mention item number 20 of court number 12, my lord. This matter may be listed on the next Thursday, my lord.
That I can't.
The date may be fixed, otherwise it will not.
You
come.
make a mention before that court on next date.
Please, your lordship, I beg to make paying for listing and CRP method for urgent matter.
Tomorrow?
Tomorrow.
Why?
So execution order is already execution proceeding is going on. 19th is the execution reporting date.
So when did you file this matter?
13th of June. 13th of June.
For motion?
Yes.
The lordship, and I beg to mention for listing on CRP IO manner and execution will be done by tomorrow, manner. So, my lord, if possible tomorrow.
Tomorrow?
Hello. May the lordship. Lordship, I beg to mention MSC 416/23 for listing 22 July.
Absolutely no. Mention it when the regular bench sits. Why there are two writ petitions?
One is dispose of matter, which was called by the respondents. The point of red litigator. That dispose of 5742 of 2011.
This is for non-payment of transport subsidy. This has
Non-payment
nothing to do. It has
Earlier
been disposed
petition
of.
get approved when there was total non-payment. That court had passed directions to consider and pass orders.
Then you got the money.
Then I got the money. Then they have rejected some part for which I have filed this present writ petition.
We have now challenged this checklist
Checklist. That
on
it's
the
not
ground that
retrospective
it is
application.
on cash payment, it is not given.
On cash payment not given, and the checklist was introduced in November 2009.
Now show me in 1971 Act, the scheme, cash payment was permissible.
There was no such guideline as.
So
this is
therefore, we
permissible
will
and this is
always
not
deem,
permissible.
we'll always deem that everything has to be by way of a check.
But 99% of the payments have been made by check, which has been allowed.
And for that, you have received that amount, the 99%.
Yes, true.
We are only concerned with that 1%, which is by
But
way of.
that
cash.
was, Lordship, as per the transport subsidy scheme, the state level committee is to scrutinize and approve the claims.
This
It was
cash,
done. It
cash.
was done by the state level committee.
Show me where it is permissible by cash.
No, there was no such that this will be applicable and this will not be applicable. There is no such guideline.
There. So it is always deemed that it should have been by way of check.
That interpretation may be taken, Lordship, but
I am only going
And
to
in
take
fact-
that interpretation, nothing more than that.
whatever payments. has been-
Unless it is mentioned by any cash payment would be allowed. Or when it is a question of claiming exemption or claiming certain benefit, it has to be in terms with the permissible mandate of the scheme. Now, the scheme do not provide that by way of cash you will be entitled to.
Scheme also does not provide that only check will be allowed. If I
That's-
may take a other interpretation,
So
Lordship.
therefore, I will give a one which is in public interest. The interpretation always should be in their public interest.
True,
Chalo.
true, but scrutiny has been
Doctor.
made on that level, Lordship. I'll just.
Yes,
have a two
Mr.
judgments,
Valita,
Lordship.
what do you say? I've heard Mr. R.K. Dev Chaudhary on the last occasion.
They have filed, India has filed a detailed affidavit. But I mean, why that this clarification was required? And accordingly, the clarification has been made, because there are a lot of discrepancies happening. A lot of misuse happening, those things have been brought in the court. And whatever, I mean, that this affidavit that has been filed, I suppose this lordship. Lordship is correct. I mean, in fact, I mean, all these kind of payments which are in the nature of government, I mean, subsidies or whatever grant, those are always done in the way of when banking.
Has to be normal. On all along, it should have been done by way of check only. So that you can very well trace it. And and as on today, in the year 2025, where even the recent judgment of Justice Pardiwala in respect to the, I think, Motor Vehicles Act,
Correct.
there was a direction that everything has to be by way of direction that all payments, even to those beneficiaries, have to be by way of bank transfer and nothing more than that. Which, cash will.
Just
Chalo.
giving a go.
You want to show some judgment?
Lordship.
Yes.
One is the judgment.
What
of
is service law?
Service law? I refer to para 6, Lordship, which refers to the guidelines and instructions issued by the department.
Hmm.
That it always has to be prospective and not retrospective, and cannot curtail down the rights which has already been crystallized.
Next.
This matter was related to service matter where there was merger of the branches between the integrated service, and the seniority position was to be determined. On that point, this case was taken up by the Honorable Supreme Court, and on that internal guidelines, para 6, Lordship.
The first sentence out here starts with, by a catena of decisions of this court, it is now well settled that by way of an executive order, the statutory rules cannot be whittled down, nor can any retrospective effect be given to such executive order so as to destroy any right which has become crystallized. Now, where is your right as per the scheme of 1971 that you will be entitled as per for cash payment? Show me that. This is only, it is more like a clarificatory. But look here, we are going to give only in respect, they are not saying that every payment has to be by way of bank check.
If I may submit, Lordship. If I may submit,
Please do.
transport subsidy scheme says, once I have made the expenses of transport expenses, I will file my application before the Industries Department of the respective state. I have filed it. It is to be scrutinized and approved by the state level committee. The state level committee, in spite of these guidelines being present, they have approved my amount because they knew that it will not be applicable retrospectively. So they have approved it. When it went to the net fee and to the DIPP, Department of Industrial Policy and Promotion, for disbursement of the amount, that time they have applied these guidelines and they rejected the amount, which is clearly Lordship may find in the order that page 42 of the read petition Lordship, which forms part of the reject order.
Hmm.
Transport subsidy claim. Date of SLC Lordship may see the second column is in 2010, February 2010 for all these periods. SLC minutes, they have approved the amount of, for different periods, there's a total amount. Then the rejection amount comes, the cash payment, they have rejected by the DIPP.
Now, they have, you see, pre-scrutiny amount as on 16/12/2014
Yes.
is
pre-scrutiny is by the
2,90,508. Amount disallowed is 8,311. Amount disbursed is 2,90,508.
Yes,
Means you got the money.
I got the money for other part, which they have allowed.
No. You got the same amount.
No, Lordship may see the
Oh, the total.
total is 298.
Summary of
disallowed
minutes of
8311.
Iman is 2,98,000.
Yes, that was approved by the
Of
state level
that,
committee.
only pre-scrutiny report on Iman.
State scrutiny report is internal Lordship, which is not part of the record. It's internal by the department.
So this pre-scrutiny was done when?
This
When was
pre-scrutiny
the-
was done
No, tell me, when was the this
2014.
standard summary of minutes forwarded by the CIC? When was it done?
It was the state level committee was dated second column Lordship 26 February 2010.
Huh?
The second column of the table
Hmm.
26.
Okay,
02,
so in
2010.
spite of this notification, the checklist,
Yes,
the state level committee permitted it.
permitted. Because they very well
But we
knew.
didn't look into this notification, the checklist.
Yes, Lordship, because they very well knew that it won't be retrospective. Because in 2006, I have already made the expenses. My total expense that time, Lordship, was 2,98,000.
Hmm.
If I would have any intention of fraud, I would have made more payment in cash. It's only some amount which was made in cash, because sometimes it's not like feasible to pay cash by check to some of the transporters for few expenses. So that was, in spite of that, I have made the claim. I have included all the vouchers and everything, which was verified by the state level committee. Once it is done, and that was also pursuant to this guideline, which came in November 2009.
Hmm.
They have approved it. Now, at the time of disbursal, the DIPP has disapproved it.
Obviously, rightly
Now,
done it.
If they required that, so
That
then
is
how
why
can
I
go
find
back in time?
the state level
2006?
committee has not filed the affidavit. The reason must be for that, because of their actions. They could not have permitted it. Could they have permitted it 2009 when there is already a guideline out there? How on earth the state level committee has permitted it?
State level committee, industry department has to support it, Lordship. But my learned
No,
friend-
industry department therefore is not supportive. Filing an affidavit, they must be in hand in glove with you.
they have filed affidavit, Lordship. They have filed affidavit, but they have to change their stand now. They have,
No,
they
we
should
have-
support.
Now they are filing the affidavit just slowly.
We have changed our stand. We have stated the state level committee is only a recommending authority. Their recommendation will be scrutinized by the DPIPP. So DPIPP is the ultimate authority to plan. So we have passed it, but we are only a recommending authority. That is.
They did not have the, I think in November 2009, the facts, you know, the state of Assam's state, I mean, the manner in which the state of Assam functions. Now we are in advantage Assam, everything is there. But at that point of time, the state level committee most probably even didn't have a facts. So they didn't know anything about this notification.
Subsequent to this, let's say after 2012, 11, then all the cash payments were rejected. Later.
Subsequent, I have no case,
Subsequently,
Lordship.
all
Subsequent, I'm
these
not
were-
also on the subsequent periods. My claim is only in respect to the previous periods.
Hmm.
I had claims for subsequent, but for that I have not made any approach to any of court, Lordship.
Shallow. Anything more?
One more, Lordship, the judgment, the compilation, page 58. Though persuasive from the High Court of Meghalaya, Lordship, on the same facts and circumstances.
Huh, Meghalaya High Court.
Lordship, persuasive,
Meghalaya High Court is Meghalaya. Meghalaya High Court is for Meghalaya. Like Supreme Court judgments are for Supreme Court, Meghalaya High Court.
actually, or only
We are
on
concerned
persuasive,
with
Lordship,
only-
I am relying upon this on the same facts and circumstances. I had the opportunity to argue the same matter, Lordship. I'll rely upon paragraph 4 of the petition. Exactly same. facts and
Precisely the point for
circumstances.
consideration is whether the point number 35 for the period from so and so will apply vis-a-vis the payment in by check. The answer has to be no. The notification has been issued in the period during which that period. I have no idea. Chalo. Good. Now my judgment becomes better when I am distinguishing this judgment. Oh, yes, you are the main person who pays them. Huh? You come here. Nobody sees you in, are you? Come here.
Lordship, petitioner have alleged that they came to know about the checklist A and B when in connection with a contempt petition. An affidavit is filed by the Department of Industrial Policy and Promotion, but that's not the correct fact, Lordship. The checklist A and B was intimated to the petitioner long back in the earlier round of litigation, Lordship.
Oh.
Wherein, Lordship.
So you are on the question of delay in
Yes.
latches.
Res judicata, Lordship, constructive res judicata. They have knowledge, Lordship, that checklist A and B was prevalent at that time, but they choose not to, challenge at that relevant
How
time.
will constructive res judicata apply?
Lordship, because checklist A and B, Lordship, they have.
That is not the subject matter of consideration in the earlier writ petition.
Lordship, it was not the subject matter of consideration, but in a subsequent writ petition, when they have alleged in this present writ petition, they have alleged that they came to know about the checklist A and B when in connection with the contempt petition that is filed by the petitioner.
Why are you not arguing in this manner? They came to know about this checklist or whatever may be when they got the money in 2015,
Lordship.
and the writ petition has been filed in the year 2020. Why on earth they have not taken any steps for 5 years? Argue that. Argue.
That's Lordship. In fact, Lordship, if Lordship takes to the earlier writ petition, Lordship, it at page, Your Honor, 137, Your Honor, we have annexed both the checklist A and B. In fact, they have knowledge regarding that they have to make, Your Honor, payment through, Your Honor, check, not by way of cash, Your Honor.
How?
In fact, Lordship, because in our earlier writ petition, this transport subsidy, Lordship, was in question. Lordship, the petitioner now that he have alleged that he came to know about the checklist A and B, Lordship, subsequently. Subsequently, Lordship, when in connection with an affidavit, contempt petition, affidavit is filed by the DIPP. Lordship, if Lordship takes to page 137, earlier writ petition, Lordship, affidavit filed by the net fee. We have cleared
One affidavit filed by?
net fee, Lordship, in earlier round of litigation, Lordship. Page 137, Lordship.
Oh, yes.
Yes, at serial
Annexure C.
number 6, Lordship.
And this writ petition was disposed of when?
Lordship, this writ petition was disposed of on
2017,
2017, Lordship.
Then
July 2017.
you knew about this thing.
Yes, Lordship. Lordship,
This
page 1,
affidavit was filed on 27. When did you file this affidavit? 12th March 2012.
Lordship, that time I was not being affected by this notification. My
Oh.
entire claim was withheld by the department, the
But
respondent.
then also you knew about this notification.
But I was not being affected, Lordship. There's no point of challenging that notification at that moment of time. It was only.
Okay,
after
the money was
2017,
disbursed to you in various dates of 2015 and
During-
2012.
No,
No, you see this. If you are relying at page 42,
Lordship,
date of disbursement 2015 and 2012.
yes.
Now these cash payments have been reviewed in 2015. All are of 2015. So why on that day you have come to know? You see, you are affected by this notification, which was brought to your notice by way of an affidavit filed on 12th of March 2012. Thereafter, you say that I had nothing to do with that notification at that relevant point of time when it was filed. But there was disbursement made in the year 2015. And more particularly, you are concerned, we are aggrieved by the disbursement made in the year 2015. When this writ petition then was pending, then also you did not challenge this then.
Because I was aware. Because
You cannot say. No.
Lordship may see the order pass.
Now
in that
comes
writ
the cost.
petition. Lordship may see the order I have annexed in Annex 3.
Heard,
that earlier writ petition.
Mr. Todi, enough. Heard Dr. A. Todi. Remaining, I think the division bench will take care of it. Your grievances.
Only one point,
Mr.
Lordship, if I
A.
have permission.
Todi, no more. Mr. A. Todi, the learned counsel appearing on behalf, Dr. A. Todi, learned counsel appearing on behalf of the petitioner. Mr. R.K. Dev Chaudhary appears on behalf of the respondent number 1. Pusto. Mr. A. Kolita appears on behalf of the respondent number 2, 3, and 4. And Mr. So-and-so
G. Das.
appears for the respondent number 5. The present writ petition the petitioner herein have invoked the extraordinary jurisdiction of the court, challenging the communication dated 2011-2009 issued by the Undersecretary to the Government of India, Ministry of Commerce and Industry, Department of Industrial Policy and Promotion, whereby various aspects were mentioned in the form of a checklist for scrutiny of claims arising from transportation of raw materials and finished products on or after 10/9/2009. Various a checklist for all claims, for scrutiny of all claims arising for transportation of raw materials and finished products prior to 10/9/2009. The grievance of the petitioner is that in the checklist number A, which is for scrutiny of the claims pertaining to transport subsidy prior to 10/9/2009, there is a requirement being inserted that a person claiming subsidy has to produce the bank statement for payment made to transporter during the period, bracket, payment only by check, bracket close. It is the specific case of the petitioner that in respect to the claims for the period prior to 10/9/2009, the petitioner's claims cannot be rejected on the ground of the notification dated the communication dated 10/9/11/2009, and more particularly, checklist A. First, in order to appreciate the grievances of the petitioner, this court finds it relevant to take note of certain facts which led to the filing of the brief facts which led to the filing of the instant proceedings. Next. On 23rd of July 1971, the government of India had notified a scheme for grant of subsidy on transport of raw materials and finished goods to and from certain selected areas with a view to promoting growth of industries. First, the said scheme, hereinafter referred to as the Transport Subsidy Scheme, was amended from time to time. First, the petitioner, who is in the business of what is your business?
Roller mills lottery.
Huh?
Stated in
Where?
with respect of roller mills, rice mills, and roller mills.
You don't know. That is also hidden.
Hidden lordship, but somehow it's not stated in.
Huh? How do I know? I'll take the name from the
Floor mill lordship.
Huh?
Floor mill in earlier writ petition order is mentioned. Although I've skipped in the writ petition, so observe is the floor mill.
a perusal of the writ petition do not show as to what business the petitioner is in. Be that as it may, the petitioner submitted claim in terms with the said transport subsidy scheme for various periods. First, the details of the details of the period of the claim and the amount so claimed by the petitioner are mentioned hereunder. A page 8 আছে এই মাজৰ এইটো গুচাই দিব state level committee এইটো গুচাই দিব এইখনত এইটো এইখিনি গুচাই দিব First, it is the further case of the petitioner that although the petitioner submitted those claims, the petitioner was not paid any amount in respect, not paid any amount. This resulted in the petitioner filing a writ petition before this court, which was registered and numbered as WPC number 5742/2011. First, it is very pertinent at this stage to mention that in the said writ proceedings, that is WPC number 5742/2011, the respondent number 4 had filed its affidavit in opposition on 12th of March 2012. In the said affidavit in opposition, various aspects were mentioned on the merits of the said proceedings. Be that as it may, it is very pertinent for the purpose of the present dispute is that to the said writ petition, to the said affidavit in opposition, the impugned communication dated 2011-2009 issued by the Undersecretary to the Government of India was enclosed as Annexus C. The record reveals that during the pendency of the said proceedings, the respondent authorities have disbursed the amount, the claims so made, as referred to herein above. First, pertinent herein to mention that though the SLC, the state level committee for scrutiny and verification of the claims, have permitted all the claims, the claims so made by the petitioner, including the claims based upon cash payments. But the respondent number 1 rejected the claims of the petitioner insofar as those payments made by way of cash. First, the grievance of the petitioner in the present proceedings, as would appear from Annexure 4 to the present writ petition, is that the petitioner received various amounts on 5/2/2015 and while receiving the said amounts, the petitioner was denied the claim insofar as cash payment. First, the record further reveals that the writ petition being WPC number 5742/2011 was subsequently disposed of by the judgment and order dated 21/7/2017. And there was a direction issued to the respondent number 1 herein to cause an inquiry and verify as to whether the petitioner is entitled to the balance amount as claimed in the statement enclosed to the affidavit dated 3/5/2017. Post- An order thereupon was passed on 1st of August 2018, whereby it was mentioned that the petitioner have been duly paid what the petitioner is entitled to, save and except the claims so made on the basis of cash payment. The record further reveals that this order, which was passed on 1st of August 2018, was put to challenge by filing the present writ petition. You have challenged this. Have you challenged this order? No. Huh? Okay. It is the record reveals that pursuant to the order passed on 1st of August 2018, the present writ petition was filed on 21/1/2020, challenging the communication issued on 20/11/2009. Now you have challenged that order. Why you are saying you are not challenging? Page 19. See the writ petition. Well, we believe what you say. Writ petition, page 19. Isn't it? Very good. Yeah, go ahead. Challenge the order dated 1/8/2018, as well as the communication dated 20/11/2009 and checklist A. By filing the present writ petition on 21/1/2020. The petitioner further have sought for a direction upon the respondent authorities to disburse the sanctioned transport subsidy amount of rupees 2,46,149. What is this? This is the total of that, nah?
Yes, but total of the cash reject.
No. Why you are asking 2,46,000?
Lordship may refer to page 10, the table inclosed. On page 10, the table which I went. 2,46,000.
Where is this 83,000?
83 Lordship may see
This is not here.
serial number 8 Lordship. Serial number 8, the amount was 34,63,000. Amount disbursed is 33,79,000. And the serial number 9 is 13,34,000. Amount disbursed is 13 lakhs. Balance of that.
And claiming the amount of rupees 2,46,149, the details of which have been mentioned at paragraph number 12, on the basis of the details which have been mentioned in paragraph number 12 of the writ petition. The record reveals that this court, by an order dated 27/1/2020, issued notice the materials on record show that the respondent number 1 had filed an affidavit in opposition on 18/2/2021, wherein Various preliminary objections were taken as regards the maintainability of the writ petition. Wherein there were preliminary submissions made as to the reason why the checklist was inserted. To write the communication dated 2011-2009. It was mentioned in the said affidavit in opposition that as per clause 6, Roman 13, small 13d, of the notification dated 19/7/1978, the Director of Industries in the States/Union Territories concerned were required to carry out periodical checks to ensure that the raw materials and finished product goods in respect of which transport subsidy has been given were actually used for the purpose by a system of scrutinizing of consumption of raw materials and the output of finished products. It was mentioned that in terms with clause 6, Roman 14 of the notification dated 19/7/1978, the Directorate of Industries of the States/Union UTs concerned were required to draw up a procedure and arrangement for scrutinizing the claims for transport subsidy. Full. It was further mentioned that the Comptroller and Auditor General (CAG), which conducted performance audit of transport subsidy scheme in its report submitted in November 2009, pointed out several instances of irregularities. It was also noticed during a review exercise by the Department of, what is that? Department of Promotion of Industry and Internal Trade, bracketed DIPP. In the year 2009, that all states/union territories were not following a uniform system for examination/scrutiny of the claim documents. And it was therefore felt that a uniform checklist for scrutiny of claims under the scheme may be applied across the board. First, at paragraph number 6 of the said affidavit in opposition, it was mentioned that there was a conscious decision taken at that time to disallow payments made to transporter in cash so as to eliminate the possibility of allowing doubtful, unscrupulous claims. First, the integrated finance wing and the internal audit wing, who were also consulted in the matter at that time, opined that cash payment of transport charges is not permissible under inverted comma receipt and payment bracket close rules, and that proposal for such relaxation is not only in violation of the rules but will invite similar requests from other state governments. It was accordingly decided that the checklist issued by communication dated 2011-2009 may not be relaxed insofar as mode of payment other than check is concerned. Where is these rules? You are referring to these rules. Where is it? This receipt and rule, payment rules. Huh? What? Come here, come here. Yes,
It's not annexed here, Lordship.
you have it.
Not with me.
You are relying on a particular aspect, but you don't know anything. Huh? People will laugh. The Deputy Solicitor General of India does not know what is receipt and air rules. I also don't know, but you are the one who is placing it. You should know. What are these rules? Receipt and payment. That is the basis on which you have done.
Yes.
Then who is that? What rules?
This would be the financial.
You do know the name of the rules, the financial rules. Okay. 15 minutes?
I'll make it.
Chalo. Pass remaining. I'll pass the remaining order at the end of the board. You go and find out, get it up. Because that is a very important thing, because this will take care of the Meghalaya judgment. Because that rule was already there.
Yes.
And if that rule is already there, therefore from 1971 or 78 itself, there could not have been any cash payments on this. So any other cash payments of the petitioner is there, kindly try to realize. Who wants to be a party?
6.
Huh?
Napajuti Bora.
Oh, that matter. This is an application filed to implead Sri Nabojyoti Bora, the opposite party number 6 in the present proceedings, as a party to the accompanying writ petition. First, it is relevant to take note of that the presence of the opposite party number 6 of the present application is required for an effectual adjudication of the dispute. First, in addition to that, the counsels representing the respondents also do not oppose the prayer. Considering the above, the opposite party number 6 is impleaded as the respondent number 6 in the accompanying petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days from today. And the registry, on the basis of the said fresh memo of parties as well as the order passed herein, shall make necessary correction in the cause title and also update the same in the CIS. First, IA stands disposed. Now, next. In view of the order passed in IA number, main chronology, IA number 2060/2025, this court issues notice upon the respondent number, newly impleaded respondent number 6, making it returnable on 21st of August 2025. An extra copy of the writ petition after making necessary changes in the cause title be furnished to Mr. G. Boisher, the learned standing counsel of the Guwahati High Court, within 3 days by Monday date to deliver, so that Mr. G. Boisher is in a position, the learned standing counsel, Mr. G. Boisher is in a position to effect service upon the said newly impleaded respondent number 6 through the registry of this court as well as through the office of Learned Member Motor Accidents Claims Tribunal, Noga.
Public.
It's almost 50 years since the petition.
Compassionate appointment.
And father of the petitioner died on 1976, Lordship. Since 1991. Minor, my lord, at that point of time. He was a
Mr.
minor.
Counsel, I can't help you. I am a very bad judge on compassionate appointment. I think you know that. And you cannot escape me with this matter. That is another very sorry state of affairs. So the only logical conclusion is dismissal. You also agree.
Lordship also passed one judgment in similar case.
Oh. See? Not one, and there are many judgments. And recently that was another
Yes.
case. Now, what is that name?
Sikha Datta, Lordship.
Sikha Datta is okay. No, this one. This Debabrata Tiwari.
Lordship.
Ah. Debabrata Tiwari. So we quote this and finish it. Heard Mr. S. Upaidya, the learned counsel appearing on behalf of the petitioner. Mr.
N.K. Sharma, Lordship.
You are a standing counsel of the Guwahati High Court?
You have a petition.
Don't. There's none appears for the Guwahati High Court when the matter is called up. The petitioner herein is aggrieved by the non-consideration of his case for appointment on compassionate basis in terms with the notification dated 3/1/2017 issued by the Guwahati High Court on the administrative side. The case of the petitioner herein that his father who was working as a peon where
Under the district judge, my lord. Kachar, Silchar,
under the
second session judge.
in the establishment of the district and session judge, Kachar as Silchar, expired while in service on 16/4/1976. First, at that time, the petitioner's age was 1 year, 11 months, 15 days. The petitioner thereupon, the mother of the petitioner, though applied for, none appears. Though, can't help you. You give more importance to other matters than the Guwahati High Court matters, then obviously.
That is also a Guwahati.
You
High
want,
Court
I
matter.
can put that line also in the order.
Court number 17 Guwahati High Court matter. Court number 17 Guwahati High Court matter was there. That's why. I'm sorry. I beg
Court
your
number
pardon.
17? Guwahati
is-
High Court?
There is some other matter, my lord. not
Fantastic.
concerning,
So you
not
give
concerning
importance to
the
other
employees.
courts. Let me complete it. Then by the time I'm dictating, I may reconsider your request. Yes. The mother of the petitioner applied, sought on various occasions. It is the case of the petitioner that the mother of the petitioner on various occasions met the appointing authority but the said requests were not considered. It is under such circumstances, on 17/4/2017, the petitioner submitted a communication, the representation to the district and session judge Silchar Kachar, which was not considered, and it is under such circumstances the present writ petition has been filed. It is relevant to take note of. That when the petitioner filed the writ petition in the year 2018, his age was 42 years. Full. After the death of the father of the petitioner, when the petitioner was just around one 1-year-old baby child, the petitioner survived. And presently, as stated by the learned counsel appearing on behalf of the petitioner continues to aspire for a job in the establishment of the district and session judge Kachar. What is he doing?
Tuitions.
Huh?
Tuitions.
This court made a specific query upon the learned counsel appearing on behalf of the petitioner as to how the petitioner is managing his livelihood. In as much as on date, the petitioner is
50 years.
almost 50 years. The learned counsel submits that the petitioner manages his livelihood by way of tuition. Next. The record reveals that in spite of notice being issued, the Guwahati High Court or even the district and session judge, who are respondents to the present proceedings, have not cared to file any affidavit in opposition. First, the question therefore arises as to whether this court presently would be in a position to issue a writ in the nature of mandamus for consideration of the petitioner's case for the purpose of appointment on compassionate basis. It is relevant to take note of. First, for the purpose of that, this court finds it relevant to take note of a recent decision of the Supreme Court in the case of State of West Bengal versus Debabrata Tiwari and others, reported in 2023 SCC Online SC 219, wherein the Supreme Court called out the principles for making compassionate appointment. First, paragraph number 32, 33, and 34 of the said judgment, being relevant, is reproduced hereunder. First, next. The law declared by the Supreme Court in the above judgment makes it clear that the appointment on compassionate ground is not a source of recruitment, and the reason for making such a benevolent scheme by the state or the public sector undertaking is to see that the dependents of the deceased are not deprived of the means of livelihood. It was further categorically observed that the appointment on compassionate basis are made in order to enable the family of the deceased to get over the sudden financial crisis, which have resulted on account of the death of the sole breadwinner. In the instant case, it would be seen that the petitioner survived almost 50 years after the death of his father. He has a source of livelihood. Under such circumstances, in the opinion of this court, the issuance of any directions for consideration of the case or for appointment on compassionate appointment, for compassionate appointment, the consideration of the case of the petitioner for compassionate appointment, in terms with the scheme of 3/1/2017, do not arise. Accordingly, this court, therefore, does not find the present case a fit case for entertaining the claim for compassionate appointment, for which the writ petition stands dismissed. However, in the facts of the case, this court is not inclined to impose any cost. Consideration, I can't reconsider. None appears for the respondent. Where are you? It's Kedar's place. Anything?
That is the finance has given the concurrence. But my lord, the procedure says that my lord, we will have to now place it before the legislative department. And accordingly, it was placed. It will have to be placed before the legislative department before placing it before the cabinet. So the judicial department forwarded it to the legislative department. Now they made certain observations. What to make kindly see.
Again.
Yes, some what they pointed out. Perhaps it will have to be looked into whether they point out some vital points regarding the drafting of the entire rules.
The enabling provision? What is this?
Under which the rule has been framed, under what authority? That part, you have to be
What is number 8? Publication and filling up provisions.
regarding whether that direct recruitment part. The specific rule number has not been mentioned.
Who made these rules initially?
Draft rules perhaps.
No, High Court never makes these rules. All these rules are made actually by the legislative department
Yes,
itself.
Otherwise, my lord,
No, these rules are to be made by the legislative department. So why on earth the legislative department, when they made the rules, made this mistake?
for this draft rules, my lord, I can't say who has made it.
No, obviously, even I'm telling you, while we were considering of revamping the Guwahati High Court rules, and there's a committee in that regard, we continue to have a member of the legislative department.
That's what we both were discussing that we propose before this honorable court, at least my lord, a secretary who is looking after this entire issue. If lordship permits, my lord directs, we can be, my lord, present on the, my lord, before the committee, not before the court. So, my lord, apprise this on this particular point, my lord, whatever is there in this court. At least any day next week, my lord. Subject to, my lord, what this honorable court says. To have a foolproof rule, my lord, amended rule, that's part.
Where are the draft rules? Hey, Kali, এখন কিবা এখন 2025 And from here, after the legislative department, what happens the next?
It will be, my lord, placed before the cabinet.
Then the cabinet again puts to the finance.
No.
Oh, yes. Again,
No,
another
no.
rule change.
Cabinet not required. But now finance has given the note. This is the, my lord, of concurrent.
Again, it will go to the finance.
No, it will not go.
Finance, that is okay. Now, again, the changes which the legislative department, what is the problem? We were not able to do it. এখন draft rules can go. Hey, Not tell me one thing, when you are making the building bylaws of the GMC, why there is a preamble? Tell me, there the legislative department has no business. I'm asking you, because the building bylaws of the Guwahati, of the GMC has a long preamble. What happens, why it has happened and all.
PM should not be concerned.
What is wrong with you?
Preamble, it has been said how this rule
No.
was, it has to be there.
There. So it is there. What is the problem with this?
Because strictly, my lord, while drafting this note.
It seems the state government does not want these rules.
No, that's
No,
not.
it appears that. No, Mr. Gugoi, this seems to be the apparent, because why the legislative department earlier did not raise this issue? Because they are the people who drafted it. This drafting is never done by the judicial department or any other department. Even the finance do not draft. All drafting is done by the legislative department. Isn't it, Mr. Chaudhary? And you remember, you have written that book on GMC. The GMC building bylaws has a preamble. A very long preamble of, I still remember, it's a very long preamble. And you don't have a problem? The legislative department there does not have a problem, because it is one of the limbs of the government. It seems like, but here what is wrong? When there is a reference to a judgment given by the Supreme Court?
Even then, well, this is not the main point.
This is the main point. Then you see, preamble is not required in a service rule. See,
Yeah.
the draft, first you see, the draft rule is not in a proper format. So the legislative, they made it. Preamble is not required in service rule. The enabling provision under the SOI is framed in not provided in the draft rule, under which the service rule is made. Is it required?
It is required.
Why?
So, my lord, whatever CS, my lord, the department.
No,
has
I'm
found
asking
is-
you. let's see the GMC Act. Under what provision it is made?
They have to be under the provision, some provision of the act, my lord.
No, when act is made is under what provision? See the preamble, under what provision it is made? No. There the legislative department has no problem.
No, not on the, my lord, point of, my lord, preamble, or you may see the other points, my lord, not only on the point of preamble.
No, I'm on 1 to 3.
One, yes,
Now let us come to 4.
my lord.
Sub-rule 4 of Rule 1 says about merger of establishment, but this is a service rule and shall deal with only service conditions of the employees and not with so and so. So by this rule, they are going to do away with the chief judicial magistrate and so on, because this is a combined rule. This rule will be replacing the 2 rules under the chief justice establishment as well as the district judge establishment. So wouldn't there be a requirement of a merger?
My lord, those things are, have to be clarified now. my lord.
This is what is mentioned.
No. Now, my lord, against this particular, whatever views they have given, now the file will come to the, my lord, registry of this honorable court. If it is clarified, of course, my lord, that's a different issue. They have given their views. It's not a final one. They've said that these are the view, loopholes or, my lord, flaws that they have found in the rule. It is not a final one. That can be clarified, man.
No, what you are doing out here is, we put it out there in a judicial order that they are not inclined. Go and file an appeal before the division bench. Better.
So that's why I say, my lord, let
And
them-
therefore the High Court shall pass appropriate directions, issue the appropriate notifications in compliance with these rules. And then follow by way of, because the High Court can pass order, or these communications. Because this would not happen. It has already taken how many years? Huh? No. Lekho.
But before that, if at least whatever I have said, my lord, let he be present, but secretary be present before the board.
No, it's okay, not necessary.
But
Yeah. It is seen from the records. And full stop. Pursuant to the order passed by this court on 26/6/2025. The Mr. B. Gogoi, appearing on behalf of the Finance Department, submitted that the Finance Department have given concurrence to the to the draft Assam District Court Employees Service Rules 2025. It however, now Mr. B. Gogoi, the learned standing counsel for the
I'm appealing-
judicial
my lord,
department,
I'm appealing as additional element for all the state respondents. As additional element
additional easy. No,
for all the respondents.
Huh?
For all the state respondents, I'm appearing in this case,
Oh.
not only for the final.
Mr. B. Gogoi, who submits that he also appears
Judicial
for
department.
the judicial department, submitted that the legislative department of the government of Assam have now raised various objections. And in that regard, the note, the file note, the notings and accordingly have again placed the matter before the judicial department. He submitted that the legislative department of the government of Assam as would appear from the file noting.
Endorsement, letter 16/7.
No, this is a file noting, no?
Yes, this is the endorsement, views of the legislative department.
It is in the file,
16/7.
in the file noting. Dated 16/7/2025. Would primarily show that the draft rules so prepared are not in the manner in which it should have been prepared. And appears to be with full of flaws. The said file noting was placed before this court. Full stop. The finance approval is kept on record and marked with the letter Z3. And the file noting so provided by the judicial department is marked with the letter Z4. Full stop. Next. It therefore appears from the stand which have been taken by the state of Assam that there is no possibility that in near future the draft service rules would see the light of the day. Full stop. Under such circumstances, this court, therefore, would take up the instant proceedings, the writ proceedings, on merits, on 31st of, and thereby fixes the instant writ petition on 31st of July 2025. Full stop. The Guwahati High Court on the administrative side, as well as the state of Assam, the proceeding, the instant proceedings, the group of petitions herein now being taken up, now as would be taken up on merits, would not, however, affect the Guwahati High Court on the administrative side to pass appropriate notifications insofar as those in exercise of powers under Article 235 of the Constitution so that the services, so that the posts. Which are not part of the establishment of the Assam Assam Chief Judicial Magistrate Establishment Ministerial Service Rules 1987 and Assam District Establishment Ministerial Service Rules 1987 are duly regulated.
In regard to the appointment of respondent number 5, Lordship, he is the ST Hill candidate, Lordship. And he was appointed in the unreserved category, Lordship. Taking the age advertisement, your Lordship will find annexure 4, page 17. For a post of peon in the Principal Judge Family Court, Kasar Silchar, Lordship. And as per clause, there is a special criteria mentioned that minimum educational qualification is class 8 passed, and those who have passed HSLC or above shall be.
Respond number?
Respond number 5. So there is a special lordship criteria mentioned as per clause 4, and the petitioner is having a HSLC pass lordship and having a certificate of driving license and lordship in computer. So he participated in the advertisement and his name appeared in lordship serial number 47, page 23.
Where is the advertisement?
Advertisement page
Shall
17.
be ineligible to apply for the said post. Okay. Now, thereafter,
Thereafter, lordship applied. And lordship paid.
where is the respond number 5 in that eligibility list?
Page 22, Lord. Serial number 36, from below the second person. Lord. He is a STH candidate, Lordship. He is a STH candidate. Page 22,
Serial number?
36.
Okay.
And his date of birth is Lordship 1/11/1980. So he crossed 40 years, Lordship.
So,
So Lordship, the advertisement says, Lordship, on the date of advertisement, if any person is 40 years, he can be,
no, but he is an STH.
Lordship, but he was appointed in unreserved category. He has taken the benefit of age relaxation and then appointed in the unreserved category, Lordship. There are 2 posts vacant for, the advertisement says 2 posts for unreserved category and 1 post for OBC category. So I'm not aware about.
So, you mean to say then an STH cannot apply to general category posts?
Lordship, within that, Lordship, as a general candidate, Lordship, but he has taken the benefit of age relaxation.
So a person, an STH, who is otherwise entitled to take benefit of the age relaxation as has been given by the government.
If stop ST category, Lordship, but he has applied in
Show me a judgment on that.
Lordship, that is 2014 Durga Swarti case, Lordship. That was it. Para 12. Judgment relate RK Suburban and Indra Swan.
No, but where does it say out here he would not be entitled to the relaxation insofar as his age is concerned?
Says if completing the unreserved category lordship, then if he is applying for unreserved category, then he cannot take the benefit of unreserved category lordship. Reserved category lordship.
No, as regards his age,
Lordship, as now
no,
my.
he may not
understanding says-
have anything to do with as regards when it is as regards an unreserved category. It will not be that he will be given a preference because he is an STP. That is not in doubt. The law is well settled. But I'm saying, but when a reserve category candidate is otherwise, there's already an age relaxation for him as per the government norms. So then why he can't participate?
But now update one OM lordship. I was not aware about that OM, but as per this advertisement lordship, if a person is required to apply for unreserved category, then he is a general candidate lordship. And
But he would then also get the benefit as per the STP because of this office memorandum.
today, it was
Without this OM also, the law, I've done many judgments on that. Because for these people, this is the reserve category candidate, I think it is 45, isn't it?
45.
now as per they are 45 lordship.
No, earlier also, there are many judgments I've delivered. One, I think Mr. Debojit Das was appearing, one matter. That is 45. And this is long time back. This is in continuation of that.
51 lordship.
Fact of the matter is on the day of selection, my lord, this OM was holding the field.
This was, OM was holding the field.
Yes.
Then what case you have?
Then I have no case. If
Yeah.
it is goes by this OM lordship, then I have no case. And if
No,
it-
because here category means the relaxation of age will be given as per the government norms. Shall-
Apart from that, my lord, it is not the case of the it was not the case of the petitioner that he was at serial number 4. So the locus of the petitioner also is a question because
our case is that
it is
lordship,
not
there are
his
numerous
case that
illegality.
I was at serial number 4. If the 3 goes or 2 goes, I come in. It's not his case.
Ellison. What is the judgment? Ellison,
Yes,
1957,
yes.
Supreme Court.
But our case is that lordship, there is complete illegality conducting the selection lordship. So on that ground, this petition was filed lordship.
But you are challenging, but under no circumstances you will come in.
Lordship, if the entire selection process goes, then.
No, why will the entire selection process go? There's only one person who has been selected. You are only questioning the appointment of respondent number 5.
on the basis of
You are
that
not concerning the appointment of other 2. There were 3 posts.
Petition, I have stated that there are anomalies in the selection process. Lordship.
How?
Lordship, he can choose basis was, that was applied by the Lordship some in the written examination also and Viva was also Lordship. There are some anomalies. For that only, we have already filed a representation, but that was taken, not.
What
taken
is your
into
pick and choose?
Lordship, some persons were selected and I am having the criteria of Lordship that clause 4, Lordship. I'm having a driving license also and computer certificate also. That was not
Huh?
taken into consideration. Lordship. Clause 4 says minimum educational qualification is class 8 passed and those who have passed HSSLC or above shall be ineligible to apply for the said post. Candidates possessing special skill may be given preference.
Hmm.
So no preference was given to the petitioner, Lordship.
Why?
He is having the driving license. I have announced, Lordship, Annexure 3, page 16.
What are you going to do with your driving license when you are appointed as a peon? Go and apply for driver.
That is criteria mentioned in the advertisement.
Driving license has no basis. Apply for a driver.
Yes, Lordship, as per government norms, if he get the age relaxation, then there is no case.
Okay. So what do you want? I should dismiss on what grounds?
So,
On which ground?
that
On
was
the ground
age
of
relaxation.
locus standi or on the ground of this one? Which one?
Age
Please. Chalo. Heard Ms. R. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. H.K. Das appears on behalf of the respondent number 1, 2, 3, 4. To stop. None appears on behalf of the respondent number 1 on call. To stop. None appears on behalf of the respondent number 1 and respondent number 5 on call. The petitioner herein have.
For respond number, my friend is respond number 1.
Yes, what do you have to say? Come. What do you have to say? Don't come up with it. Why haven't you filed affidavit? What is the case about? What is the case about?
Selection and appointment of for the post of peon of Henry Court.
Ah, okay. Now with the petition, respond number 5 get the benefit of the notification. Huh? You are the main person, you say. Does the advertisement say that anybody will get the benefit of the notification? Yeah. Okay. None appears on behalf of the respondent number 1 and respondent number 5 on call. So, the petitioner herein have assailed the appointment of the respondent number 5 on the ground, solely on the ground, that the respondent number 5 is 40 years on the date of the application, filing of the application. And as such, the respondent number 5 could not have been selected, eligible, could not have been eligible for, in terms with the advertisement issued on 1/3/2023. Full stop. Taking into account that the issue is involved in a very narrow compass, this court finds it relevant to take note of the advertisement dated 1/3/2023, which stipulates at clause 5 that the candidate must not be less than 18 years and not more than 40 years of age as on 1/1/2023. It was further mentioned that the relaxation of age will be as per government norms. Mr. H.K. Das, the learned counsel appearing on behalf of the Guwahati High Court, have placed before this court the office memorandum dated 2nd of September 2020, issued by the Principal Secretary to the Government of Assam Personnel B Department, which categorically stipulates that in respect to schedule which stipulates that the government had decided to raise the upper age limit by 5 years over the general age limit, that is up to 45 years from existing 43 years, for entry in state government services in respect of candidates who belong to scheduled caste and scheduled tribes, and by 3 years, that is up to 43 years in respect to OBC/MOBC candidates, 2 years, that is up to 42 years in respect of ex-servicemen, and 10 years, that is up to 50 years in respect to persons with disabilities. First, taking into account that the respondent number 5 was 40 years, as would be apparent, which is an admitted aspect of the matter, and the respondent number 5 admittedly also is a scheduled tribe bracket claims, the respondent number 5's age, eligibility, in terms with the office memorandum, age eligibility, dated 2nd 2/9/2020, would be 45, is up to 45 years. First, therefore, there is no illegality in considering the case of the respondent number 5 and illegality in the appointment or in the selection and appointment of the respondent number 5 to the post of peon in pursuance to the advertisement dated 1/3/2023. Accordingly, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed. Much. What is this?
Wait, please, your lordship. Lordship, my senior is engaged before some other court, your lordship.
Who is your senior?
Lordship, Mr. K.N. Chaudhary.
Oh, he's a very busy counsel. To get him is also a big problem. So give us a good date on which he will be available, along with the time also, so that we can fix it when, date and time.
22nd of this
22nd, time. No, give us the time. Kindly see, number 2. Now argue.
I'm relatively new, your lordship.
So it is the best opportunity and before the best court.
Lordship, to my understanding, this is a tender matter where the tender was terminated by the respondent authorities on the ground of non-completion of work on time. There were extensions were given. However, there were multiple occasions due to which the work could not be completed. However, the work is nearing completion, your lordship. Most of it is.
The
already
instant
done.
petition under 226 was in selling and notice inviting tender floating so and so, so and so. Oh, almost in the backdrop, this court is of the prima facie, the respondent cannot be said to, at this stage, to have deviated from this decision as reflected in the paragraph. Prima facie, further prima facie view of the court, the impunity is a result of such a, that being the position and having regard, considered all the aspects of declined. Interim order declined. And if you don't do the matter today, this will go, we'll do it sometime in the month of December. Then your senior would be available.
So I'm extremely, I apologize, Your Lordship.
December,
So the 30 date, extremely
work
apologize.
completed?
Work completed, my lord. We have done it in-house, my lord.
Work completed.
Work complete.
What remains? You have now to therefore ask for damages for
They can go
illegal
for
termination.
arbitration. They can go for arbitration if they want.
How is this maintainable? Okay, don't worry. I won't dismiss in your hands. But we'll have it sometime. This matter is, except being environment degradation, I don't think anything else. When do you want?
Lordship, anytime next week.
No, nothing. Mr. Chaudhary, you must be very busy.
No, I'm not busy, my lord.
No, you are busy.
I'm always available whenever they matter. Your lordship will notice that.
Okay, when do you want it?
Any day, my lord.
Huh?
Not to your lordship.
No, not the next week. We'll have it on, we'll keep his word. Have it on 19th of, 21st of August. The learned counsel appearing on behalf of the petitioner submits that the senior counsel, Mr. Kane Chaudhary, is not available and as such seeks for an accommodation today as he is not prepared with the matter. Full stop. Considering the above, full stop. During the course of the hearing, this court inquired with Mr. M.K. Chaudhary, the learned senior counsel, as to whether the work in question for which the present proceedings have been initiated have been completed. The learned senior counsel submitted that as per his instruction, the work had already been completed.
My lord, in respect of 7, my lord, those are commissioned. And my lord, 2 were supposed to be commissioned on, completed on 15th. This is a little, my lord, this email is of a little earlier date.
Now only Habzan and Balimara is not done.
They were supposed to be completed on 15th of July. And this email is of 16th July. 10 July.
No. In respect to Habzan,
Yes.
in progress EDC 15/7. EDC means?
Estimated date of completion.
In progress. This is the communication issued on?
My lord, 10th of July.
No, 16th of July.
16th is the forwarding, my lord. Thereafter, your lordship will find 10th of July.
Where? 10th of July. So has it been completed or not?
My lord, so far as these 2, my lord, we have not really asked. We thought that this has been completed.
Had submitted that as per his information, 7 out of the 9 work. So allotted to the private respondent. Private respondent is there.
No, my lord. We
Who
have.
has the?
My lord.
7 out of the 9 works
No, my lord, this
have
is 11
already
works.
been completed,
11
commissioned.
11 works, my lord. Although serial number 9, and in 2, in respect of 2, my lord, there are 2 installations at serial number.
No, all these are commissioned, means
yes,
it has been completed.
Yes, completed.
Out of 9 were
11 work.
11 were. Oh, we have only 9 here.
Lordship, in 2, serial number 2 and 5
Oh,
okay.
okay. Now, out of 11 works, which was the subject matter of the impugned tender, 9 have already been completed, and he is yet to receive instruction in respect to 2 remaining.
That is Habzan and Balimara.
In as much as the remaining 2 estimated date of completion was on 15/7/2025. Also, taking into account the above, This court inquired with the learned counsel appearing on behalf of the petitioner as to whether any useful purpose would be served with the present proceedings in as much as the work having already been completed or nearing completion. Full stop. The learned counsel therefore submits that he would obtain instructions in that regard. List this matter on 19th of August 2025. At what time? When your senior would be available? Busy counsel? 12 o'clock. 12:05.
Yeah.
PM. 12:05 PM.
See, Lordship, casual employee, MSCP code, Golfer.
Oh.
Lordship direction, he was reinstated. But Lordship, the salary, that remuneration not been paid. Now, once we approached before, then they said that there is a direction required from this honorable court.
That part remuneration, but.
Yes, what is the
But
remuneration?
so far as the main allowance payment and all is concerned or instruction, there is evidence from the, both from the judicial department and finance it is evidence.
The money is there.
That my lord instruction is not there. But my lord, regarding the continuation of the remuneration, what he was getting prior to the termination, that my lord, of course, the judicial, we will have to reply, my lord.
My lord, we approached the, we sent the bill to the treasury. They said that without approval of the finance department, we cannot pay. That was refused. That's why we filed the.
No. You see, in respect to casual employees,
Regime.
the finance department allots money on a particular head. Now, whether there is there or not, it will be apparent from your records. How can you midway take him out, not pay? This financial sanction is given prior to that, isn't it, Mr. Google?
Yes, it will be in the budget, my lord. By
It will
April,
be
they
there in the budget as regards the casual employee. So this financial sanction will have to be there. Then how on midway this has happened? Instructions not proper.
I'll bring other instructions.
My lord, the only problem is that
You don't say anything.
Sir.
We'll have it next week,
Right.
next Thursday. Mr. G. Bush, okay. Mr. Gugoi, you just find out only one thing. Whether there was a financial, because the financial sanction is given at the beginning.
Yes.
As regards casual employees. In what establishment is this?
but
There now you see
MSCP Gwalpur.
MSCP Golfer.
financial sanction. I think here the financial sanction will be there.
Yeah.
If it is there or not, you just find it out and let me know. And you,
Fine.
because you cannot midway. Because he has, how are you paying the earlier amount? From April until you got the money till
April 2025.
April
From the
2000,
month
no,
of
did you
May,
get the money in the month of April 2025?
Yes. After April, we have not been paid.
So
May
did
month
you
is-
get the money for April 2025? My question is that, which
Yes,
will
yes.
get it in the month
Yes,
of
sir.
May?
My lord, I have received the according fees for right of from the month of May, it has been held up. From the
So
month-
you didn't get money in the month of May?
Yes.
Therefore it seems that there is no financial year.
Probably, my lord, for this financial year, his amount has not been, my lord, allocated.
No, not, I
That's
don't
what
think,
even says
I
the
don't
protocol.
think the finance department says about him.
No.
It will give for casual, on the head of casual employees.
Yes, my lord, it will have to be proposed, my lord, before 31st of March. That
Ah.
these are the employees who are already working. That
Ah.
annual budget is placed, my lord, on 31st of March. And if it is approved, then the entire year, my lord, they will get.
Ah.
If in the midway somebody is appointed.
No,
then they
this
get
is not,
financial
mid-
approval.
this
That's
doesn't
why
seem
he's
to be
working from
midway.
2014. He's working from 2014.
Because his sanction must have been there till 2025,
March
March
2000.
2035. And for the month of April, there is no financial sanction.
That part will have to
But
come from, my
the
lord, MSCP.
Other employees are getting there, man.
that part will have to be, my lord, furnished by the, my lord, concerned authority who is engaged in. Why they have not given the budget proposal?
You find out that one.
Yes.
It has been submitted by Mr. Samaria, the learned counsel appearing on behalf of the petitioner, that the petitioner have not received any amount with effect from the month of May. First, 2025. This court inquired with Mr. G. Busher, the learned standing counsel of the Guwahati High Court, as to whether there is any financial sanction for engagement of casual employees in the establishment of the motor, what do you call it?
Motor accident claims
Claims Tribunal. Which one?
Gwalpara.
Gwalpara. Pusto. For the year 2025-26. Pusto. Mr. G. Busher submits that he would obtain instructions in that regard. Pusto. List this matter again on thirty-first of July 2025. Pusto. Mr. B. Gogoi, the learned additional AG, as well as the standing counsel of the finance department, shall also obtain instruction if there is any financial sanction for engagement of casual employees in the establishment of the Motor Accidents Claims Tribunal, Gwalpara, for the year 2025-26. On the text. For the finding.
Last office note. Neither ID card nor answer notice has been received from respondent number 6, 8, and 9. My lord.
Have you filed the affidavit in reply?
I need some further time to file my reply.
I gave you time last time. You want or don't want?
I want.
Want is with 50,000 cost and don't want is no cost. Which one?
Without cost, my lord.
No, without cost doesn't happen. Last thing. Hearing home or I'm sorry. Cost of 50,000. It is seen that this court had granted time to the petitioner to file the affidavit in reply to the affidavit in opposition filed by the respondent numbers 4, 5, and 7 by an order dated 29/5/2025. However, no affidavit in reply had been filed by the petitioner. Considering the above, this court debars the petitioner from filing the affidavit in reply to the affidavit in opposition filed by the respondent number 4, 5, and 7. In time order?
My lord, continue.
Okay. List this matter again on, we'll finish it off then. You have not filed affidavit?
Affidavit.
Okay.
Sure, the order dated 10/3/20 passed, but it's on the court. There's a genuine mistake, my lord. If I may be permitted to add the correct annexure at the end of the application.
Ms. So-and-so submits that she would file, that there is an incomplete enclosure, annexure to the affidavit filed by the respondent number 4 and 5.
Yeah.
4 and 5. She therefore submits that she may be permitted to bring on record the proper, the completed enclosure. Rusto. Accordingly, list this matter on 7th of August 2025, the completed enclosure be brought on record by filing an additional affidavit by 31st of July 2025. Interim order passed earlier shall continue till then.
Your lordship,
Oh, your case, no case.
yes, the petitioner itself has not been able to furnish the document. The petitioner itself has not been able to furnish the document, your lordship, the requisite document,
Ah.
and we have failed to establish a contact with him.
So, what to do? Dismiss?
Yes, your lordship.
That I know, as your lordship always says. Which one? Dismiss, withdraw, which one? Because your case is a fake case. Isn't that, Mr. How on earth did he have?
District is Nalbari only.
In fact, this issue arose when I heard the matter. No?
Yes, correct.
It is nobody's case.
Nobody's case. So far as his main claim is concerned, that is, he was already disengaged in 2016. Thereafter, for a short span,
It's
he was
certificate that the certificate was issued on 6/10/2000, stating inter alia that the petitioner left the school on Swan. That the said transfer, that the said school was only established in the year 1987. Put a query upon the learned counsel for the petitioner as to whether the petitioner was studying prior to that, where the petitioner was prior to that. Inasmuch as without a transfer certificate from any other school, the petitioner could not have been admitted in the said school, which was only established in the year 1987. Heard Mr. Swanso, the learned counsel, appearing on behalf of the petitioner. Anybody, government? Mr. D. Nath appears on behalf of the respondent number 1.
yes.
Mr. D. Nath appears on behalf of the respondent number 1. Mr. H.K. Das appears on behalf of the respondent number 2, 3, and 4. Full stop. The petitioner herein is aggrieved. Aggrieved by what?
Hearing for regularization.
Huh?
He's praying for regularization. Madam.
For is aggrieved by the non-consideration of the case of the petitioner for regularization. Is aggrieved by the rejection, huh?
Yes, yes.
Rejection
Annexure 11,
of
28.
the is aggrieved by the order dated 31/3/2016, by which the petitioner's request for regularization of his service was rejected. It is relevant to take note of that the petitioner was discharged from service with effect from 31/3/2016. However, during the course of the hearing on 27/1/2025, the counsel appearing on behalf of the petitioner drawing the attention to the affidavit filed by the respondent numbers 2, 3, and 4 submitted that the reason why the petitioner's case was rejected was on the ground that the petitioner was not class 8 pass, which is incorrect, taking into account the petitioner had passed class 8 and he was reading in class 9 when he took a transfer certificate from a school in the name and style of Dohoka, Dokoha High School. The learned counsel, appearing on behalf of the petitioner, drew the attention of this court to the affidavit in reply filed by the petitioner on 26/11/2019, and more particularly to Annexure R-A, which is the transfer certificate. Full stop. Taking into account the said, this court passed an order on 27/1/2025. Full stop. Paragraph number 2, 3, 4, and 5 of the said order dated 27/1/2025 is enclosed here, which is reproduced herein under. The record reveals that though this though this court had given more than 6 months' time to the petitioner, more than almost 6 months time to the petitioner, the petitioner have not been able to produce any document to show that the petitioner was transferred from some school to Dohoka High School. In as much as the Dohoka High School was only established in the year 1987, and the petitioner, and it is seen that the petitioner was issued the transfer certificate on 6/10/2015. Why on earth have you taken a transfer certificate? Next. It appears that in spite of opportunity being provided, as the petitioner failed to produce such a document, produce the certificate on the basis of which the petitioner was admitted to Dokoha High School, Dokoha, the authenticity of the transfer certificate dated 6/10/2015 is doubtful. And as such, it is therefore the opinion of this court that on the basis of the said transfer certificate, the petitioner could not have been considered that he had passed class 8. Full stop. Under such circumstances, the reason so assigned by the respondent numbers 2, 3, and 4 in their affidavit in opposition for rejection of the petitioner's claim for regularization of his service as a peon do not appear to be appears to be in accordance with law. First, Accordingly, this court therefore does not find any merit in the instant petition for which the petition stands dismissed. Oh, what is this? What is this, Mr. Mahmood?
Well, Lord, this is regarding the appointment of Chowkidar under the district and session judges establishment at Pokraja.
Then,
Well, Lord, there is an advertisement. Kindly see page 16 is the advertisement.
you have a good case?
In my opinion, it is a good case.
Because today I have dismissed all. I want to allow one petition.
Advertisement itself is wrong in many aspects because it appears that it is a motivated advertisement. Kindly see, applications
Did
are
you
invited.
participate?
Yes,
No, did you participate?
yes, I participated.
Then,
The oral marks were more than the written marks.
where?
And I got written marks more. The private respondent number 7 got more marks in oral.
No, where is the advertisement?
At page 16.
What does it say?
It's a candidate. Applications are invited
Hmm.
from citizens of India as defined under Article 5 and 6 of the Constitution for filling up the post of Chowkidar in the office of the district and session judge Kukrada. Name of the post Chowkidar. Unreserved.
Chowkidar, what oral and written marks? And there is no mention about marks in the
Marks.
advertisement.
What will be the written mark? Not mentioned.
Okay, then what happened?
Neither the oral marks, what is not mentioned. And in between, due to all these colorful activities of the landed district and session judge, the special judge, who was one of the member of the selection committee, he has given up his membership that I am not participating in this
Hmm.
process because that is not fair in his opinion. So he gave up the number and thereafter the case was the landed district judge appointed another munsif in the post of landed special judge.
Hmm.
Oblique additional session judge as well as POXO judge also. So in his place, munsif another.
What are you challenging?
I am challenging the appointment of respondent number 7 as Chowkidar because in the interview once it was.
What is the
quoted,
name of the respondent number 7?
Roshan Borgohari.
Roshan Borgohai.
Borgohari.
Oh, no. Respondent number 7 is Roshan Borgori.
Borgohari.
And you are
Jahirul Haq.
Jarul Islam. And who are 8 and 9?
8 and 9 are, my lord, they also participated, but they are not interested. They did not come to agitate the appointment of the respondent number 7. Even then, we have met the parties. One is from.
And how much marks did you get? Where is it?
In written,
Hmm.
I got
Where is your serial number?
my serial number, that's my 15,
Got it, got it. You got 6. You got total 24.
24.
And where is the other person?
And other person got 27.
Where?
That is page 44.
You got 27. And 24, you are number 2.
Yeah, I am number 2. Now can you see in the written marks he got 5.
Huh?
In the written.
Oh, there is another one. Bonomali Ray. He's also 12. He's also 24, na? And how many else are 24? Only 124. There are 2 persons who have got 24.
But that another person, he did not came thereafter. Perhaps, as I have been told, he has got some another revenue, that's why he did not come. Now, my submission is this, when the oral marks are more than written marks, and particularly when there is no mark mentioned in the advertisement that there will be so and so marks for written examination and so and so marks would be for oral viva voce, so that itself is nullified. And I am higher secondary passed as well as IIT, and he has simply passed matriculation examination, that too his marks is much lesser than me. So there is.
You passed higher secondary,
Higher secondary.
then how can you be, how can you challenge, how can be appointed? It's a grade 4? Is it graduate?
Graduate, I have.
See, Mr. Mahmood, I told you,
No, graduate.
don't do a bad case today. I have dismissed so many cases. And it started with Mr. Todi, Dr. Todi. And it has to end today with Mr.
there is,
Mahmood's case being the last case for dismissal. How many cases I'll dismiss today?
Suppressed.
Huh?
He's a graduate. For suppressed, that is the stand in the affidavit, page 49.
Absolutely,
four.
I've seen it. Is he graduate?
Yes.
Are you a graduate? Mr. Mahmood, you're a graduate?
Graduation.
I'm sorry, my lord, he's a high secondary.
secondary.
Higher secondary.
secondary.
You are higher secondary. Then
That was
how can you
suppressed.
be qualified? How can
That
you?
was suppressed.
At your instance, a person who is not eligible, how can I interfere with the selection?
My lord.
Advertisement is not under challenge.
Huh?
The advertisement which spells out the criteria, paragraph 3, page 16 of your lordship's brief. If any candidate is found to have suppressed his educational qualification.
And you are alleging malafide against the judge?
No, because one.
No, Mr. Mahmood, are you alleging malafide against the judge?
Because just on the next day, he transferred from Cochrane.
I'm not on that. I'm asking you, are you alleging malafide against the judge?
Malafide means, lordship, I have made here, there's arbitrariness and.
No, arbitrariness is a.
Selection.
Are you alleging malafide against the judge? Because you have made the respondent number 9 the judge by name
By name,
in
yes.
person. So you must be alleging malafide.
Malafide, para 10 may be seen.
Huh?
Para 10, page 11 of my writ petition. As well as 9 also. 9 from 9 we may read.
The action of the respondents, particularly that of the respondent number 9, is highly illegal, arbitrary, unfair, and against administrative law which requires interference. Then
Para 9, the petitioner assured that in the entire selection process, he did not got adequate marks in the interview, and the respondent 7, who only HSLC passed candidate having lesser extracurricular activities.
Mr. Mahmood, I'm dismissing your case with cost of 50,000. Making this, why on earth have you made this person as a party? No. Without this allegation, you should not have made him a party. This is not that.
He's got a party.
First, did you say out here that you were eligible? Did you say that you are HSLC?
I am HSLC, no.
No. Why you have mentioned having maximum qualification of HSLC passed? Kindly see paragraph 2 of your petition.
Yes. That
This is the case of suppression.
suppression means.
Suppression is there.
So when I have annexed my document.
No, why you have at paragraph number 2, you have mentioned HSLC passed is the qualification required. See?
No, there is no anything that beyond that, nobody can apply. Perhaps that is not there in the advertisement.
Mr. Mahmood, read paragraph 2. Read it aloud.
petitioner actually said that an advertisement was issued by the Landed District and Session Judge Kokrajhar on 16/12/20, inviting application from the intending candidates for the post of one Chowkidar having maximum qualification of HSLC pass.
Then that is your own case. How is it possible?
Now here, one thing, my lord, in para 3, it is written, any candidate is bound to have suppressed his education requisition or given any wrong information. So, my lord, that I have not given. In para 3,
Luckily, no cause because this court did not issue notice upon respond number 8 and 9. Chalo. Heard Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner. And Ms. S. Sharma, you are appearing? Mr. D. Nath appears on behalf of the respondent number 1. Ms. S. Sharma appears on behalf of the respondent number 2 to 6. First, the petitioner herein have challenged the appointment of the respondent number 7. Selection and appointment of the respondent number 7.
I think, my lord, if I
No, Mr. Mahmood, nothing. Upon respondent number 7, selection and appointment of the respondent number 7, date by order dated 29/11/2021 at Chowkidar under the establishment of the Learned District and Session Judge Kokrajhar, and further sought for a direction that the petitioner be appointed as the Chowkidar in the said establishment. Full stop. It is relevant to take note of that the advertisement so issued categorically mentioned that the post of the Chowkidar, that the maximum qualification for the post of the Chowkidar is HSLC pass and fluent in one or more local languages or dialects of Assam. Full stop. The petitioner admittedly was HSSLC passed, which is not denied, although which though not categorically stated in the petition, but is apparent from
annexers. Annexer.
Annexer 6 to the writ petition. First, therefore, the petitioner could not have, was not eligible even to participate in the said selection process. First, under such circumstances, at the instance of a candidate who was not eligible to participate in the said selection process, this court is of the opinion that
Just call for interview by the district judge.
was not eligible to participate in the said selection process, could not have, under such circumstances, at the instance of a candidate who was not eligible to participate in the selection process, the question of issuance of a writ in the nature of certiorari to quash the appointment or selection and appointment of the respondent number 7 do not arise. Consequently, this court finds no merit in the petition, for which the writ petition stands dismissed.
Right.
Yes, Dr. Todi. Yes, what have you found out? Got it?
Yes. The central government account receipt and payment rules 1983.
The rules made called the central government account receipt and payment rules 19. And which is the clause?
First it will come to 58, the note therein.
Huh?
58.
Page
There is no page number, the rule 58.
58, na?
See the note there too.
Scrutiny of claims. Cash memoranda which do not contain an acknowledgement of the receipt of money from persons named therein are not received within the meaning of A of the Stamp Act. Further, the mere writing of a purchaser's name and address on a cash memoranda for delivery
Insofar as a check is concerned, it is not.
cash memoranda will not therefore be regarded as sub-vouchers in audit unless they contain an acknowledgement of the receipt of money from the person named therein with stamp affixed therein when the amount exceeds rupees demand. Let me go through this. I think there is a better. Well, hell with tomorrow. Tomorrow is not there. No? Tomorrow is there. Tomorrow we are again rising early. Tomorrow we have to rise today. No? And go through it properly. I don't think that is the only thing. So it will be grievance or withdrawal of money from government account. A check drawing DDO functioning under the scheme of deployment shall not draw a check for withdrawal of money for any purpose.
Part deals with worship.
Hmm?
This part deals with the general rules relating to claims for withdrawal and manner of payment. That starts with Rule 28.
Hereby makes the following rules regulating the custody of the consolidated fund and the contingency fund, the payment of money in such funds, the withdrawal of money therefrom, the custody of public money other than those credited to such fund received by or before behalf of AIR and their payment into public account of India and withdrawal of money from such account and so on. So. No, because what is the problem out here? There is a big problem. If we allow this petition, the ramification here is just 2 lakh something. But the impact which it has is like this. Various amounts, which is undisclosed amounts, can be shown as cash receipts.
Yes.
And then it would be legalized. It is a case, it would be legalized by the disbursement of the subsidy.
Yes.
So under such circumstances, the question does not arise, allowing his petition. But anyways, let me have a look at this. I'll pass to we'll have it on Monday again.
Monday, perhaps it is sitting late.
Oh, Monday I have a problem. I'm not there. Tuesday. List the matter again on on Tuesday at 2 p.m.
I consider for in personam order.
Huh?
As order is not precedent, and in personam order, if lordship considers otherwise.
What?
If lordship considers otherwise in favor of the petitioner, maybe in personam and not as precedent.
No. Here there is a lot of ramification. Here, if you have only asked that you should get only that amount, it would have been different. But how do I take care of your challenge to that notification? You get the point? Dr. Dori, I have, if you see in one case of it's the Sahewala, I've allowed when they have made the certain changes. He was appearing in that. That was another notification by which they wanted to insert electrical components that I have allowed it. This would not be much on public interest, but here there is a public interest element, which if I allow here, it would be opening Pandora's box for money laundering.
That has to be looked
That is the main issue.
at. Exactly.
You see, here there is no doubt that the petitioner may have paid that. I'm not on that. But the question of the implication is very high. And when the implication is high, the courts cannot issue that. The public interest, public exchequer being hit. And more particularly, there may be cases of money laundering. So one has to take note of that. You may be entitled to that. That's another thing. I'm not going to say do anything on that, but you may have rightfully given everything. I'm not doubting that. But the question is the implication.
Protect the interest of the
Huh?
petitioner as well as the interest of the state.
Here the question is vis-a-vis the interest of the state. And then it will open up many issues. We'll take it up on
Tuesday.
Tuesday, showing it as part of